Good morning, Your Honor.
Mr. Gregg made it. Great. All right. Well, good morning, everybody. Let's proceed. Mr. Gregg, you'd be first. And everyone knows there's a rebuttal period. If you'd like up to 5 minutes, just let me know.
Yeah, I would like to reserve 5 minutes for response and rebuttal, please.
All right. You got it.
Good morning, Your Honors. My name is Steve Gregg. I represent the appellant Stephen Cook, who's the former husband in this case. This appeal arises from a post-judgment alimony enforcement action. The parties entered into an agreement in their original dissolution of marriage action, wherein each party was provided with about a little over $1.3 million in equitable distribution. And additionally, the parties agreed to an alimony provision at paragraph 13 of the final judgment.
Mr. Gregg, can I just jump in before going into the merits of your argument? Can you briefly address our court issued an order to show cause as to whether or not we do have jurisdiction? Can I have you touch upon that and let us know what is your position? Do we have jurisdiction to proceed, or is this a non-final, non-appealable order?
It's my opinion it is a final order because of the issues that are subject to the appeal ended all judicial labor, and there's nothing further for the court to do. The court made the two issues on appeal are, one, the interpretation of the alimony provision, and two, whether or not there was competent substantial evidence to support the court's finding or some alternative version. Both of those issues have been finally resolved by the court. The court made an absolute determination of its interpretation of the agreement. There's nothing left for the court to do in that regard. Additionally, the court denied the relief that my client was seeking, actually denied both parties the relief they sought, and ordered the parties to do a bunch of things that stemmed from the court's misinterpretation of the alimony provision.
So it's your position that even though the court did not set an exact amount for alimony, it did finally interpret that alimony provision and the claims regarding whether it is surplus or arrears. Is that your position?
Yes, Your Honor. At the very least, it would be Mr. Cook's position that the interpretation issue must be decided, because even if the court were to find there was or wasn't competent substantial evidence, or that the court maybe does have additional evidence to take, the court has set the track in terms of what the interpretation is, and we're going down this path. We need to first determine whether or not the court got this right in its final determination of the interpretation.
Okay, thank you, Mr. Gregg.
Yes, Your Honor. May I continue?
Yes, sir.
Thank you. And so the alimony provision at issue prescribed that the former husband pay permanent alimony to the wife in the amount of $6,000, but there were some additional conditions based on anticipations of the parties. The additional provisions go on to prescribe that the former husband is entitled to, quote, a dollar for reduction in his monthly alimony obligation effective the first month the former wife receives a regular Social Security disability payment. The provision also prescribes that the former husband is entitled to a further reduction, dollar for dollar, based on the difference between the private health insurance the former wife had at the time of the dissolution, as compared against the cost of Medicare and reasonable supplemental insurance, and that those are to be one-time deductions.
Well, let's talk about that, Mr. Gregg, because would you agree that paragraph 13, that's the crux of your argument? If you look at paragraph 13, and I'm pulling it up right now, of the parties' agreement, it sets for, and it provides that, and it goes through, and it explains, and then don't you think the language of that paragraph appears to be that it is an ongoing, the provision provides, or at least an interpretation provision can provide for ongoing adjustments to the alimony based on subsequent changes in the premium supplement costs? Because if you look at that paragraph, it makes reference to that. Why are you taking the position that this provision only calls for a one-time adjustment?
If I may ask one clarifying question, Your Honor referred to, because it says that, and I'm not sure what that refers to.
I'm looking at I'm referring to paragraph 13, and that's what I was saying, that paragraph the way that it sets forth upon reading it, it appears that it does call for adjustments to the alimony based on subsequent changes in the premiums and supplement costs. And I guess my question to you, your argument is very laser, that it's only a one-time and myopic interpretation. Why doesn't that language lend itself to the other interpretation that it does permit ongoing adjustments?
Okay, I would start with this. There's kind of a binary option here. Either the wife will be granted Social Security disability or she won't. That's what that contingent clause at the bottom is. If she's not granted, then these other things happen. We know she was granted Social Security disability, so we're going through the first only. The second one is of no import. It says, if the wife is granted Social Security disability benefits income, there shall be a dollar-for-dollar reduction in the alimony prospectively only, and beginning the first month that she receives a regular payment without any retroactive application. There's nothing in there. It doesn't contemplate multiple reductions. It doesn't use the plural reductions. It does use the indefinite article A, which I believe I raised in the brief based on this court's case Judy v. Judy. There are no requirements that the parties exchange financial information. There are no indicia that they intended to do these repeated recalculations. It just says that the first month she receives a regular payment, that would be the amount she receives. And since that time, Mr. Cook has never asked for an additional modification due to any increases, and there have been increases. Moreover, the former wife in the lower court case, after this case was heard and dismissed as a non-final order in 2017, the former wife took the position that there was a one-time alteration in her, or reduction in her alimony based on what she received for Social Security disability, and it wasn't to be touched again. And I believe I cited to those portions of the transcript.
And I know, Mr. Gregg, you read that portion, that first portion of paragraph 13, but there's also another provision that continues on that says that if the wife is granted Social Security disability benefits, then it goes on and it explains, it also explains what needs to be done. And I guess I'm having difficulty with your argument that this is simply a one-time adjustment. And in fact, even the court recognized that it appears that the agreement provided for continuing adjustments, which would make sense to the alimony as necessary. We all know with Medicare, things fluctuate up and down. So help me understand why this simply is a one-time thing.
Well, Your Honor, respectfully, it calls for a one-time thing by using reduction. It doesn't say multiple reductions. Again, it doesn't call for any of the things you would expect in the scenario. What Your Honor is suggesting may have been a perfectly appropriate solution for the parties, but simply not what they agreed to. It's the former husband's position that each of these, and read in combination in pari materia, it's clear that there was meant to be a one-time reduction for each of these items. And then should there be future needs for modification, that would be appropriately brought through a modification action. Otherwise, these people are going to be financially entangled and fighting with each other, for the rest of time. Okay. But as to your question about specifically about the benefits, I believe the language mirrors the Social Security language and the benefit language above. And whether or not the Social Security benefit, or I'm sorry, the Medicare premiums change or the reasonable supplemental insurance changes, that is a fact, but it would be an extrinsic fact that would be considered parole evidence in terms of interpreting this agreement. And the court didn't take notice of any of those things, nor did anybody argue there was an ambiguity.
Okay, and maybe this is something, Mr. and I know I focused on that, but it just common sense that it makes sense that Medicare health insurance benefits does, in fact, I think the court recognized it does fluctuate. It does change. It does that. And so anyway, I peppered you long enough for that issue. And I see, I appreciate your position, Mr. Gregg.
Thank you, Your Honor. I appreciate the questions. If it may inquire of the court as to how much time I have remaining.
You have 9 minutes and 57 seconds.
Thank you, Your Honor. So I believe I think we've covered most of the issues through Her Honor's questions about my presentation in terms of the first issue. As to the second issue the former husband raised was that the court essentially ignored the competent substantial evidence in front of it and denied the relief he was requesting. And I apologize, Your Honor.
Well, let me just ask you a question, because when you say competent substantial evidence in front of it, isn't the judge entitled to assess credibility? And that,
yes, Your Honor.
So I mean,
Without question.
Went and teed off on your expert and said, I don't believe a word he said.
Correct. And I believe that all stemmed from the court's misunderstanding of the agreement. What the issue, I believe,
maybe it did, but he had the prerogative to believe or not believe any or all of the part of any testimony of any witness, and he was pretty direct in his assessment.
he was. That is accurate. Again, I would say that with regard to the court's finding, I think it all stems from the misinterpretation. If Your Honor reviewed the transcript, the court was very fixated.
The only reason I asked that question, if his interpretation was correct, then your issue 2 really is a non-starter. If he's wrong, of course, you get a redo on everything.
That would be correct. It all stems from the interpretation issue. I agree.
All right.
And based on the court's interpretation, the court was very fixated on which amount of the reasonable supplemental insurance that the former husband's CPA focused on and selected as the amount. The court made a big deal about criticizing the CPA for cherry picking this number, as though it was the purpose was to pick the lowest amount to cram down the former husband's obligation as much as possible. In reality,
isn't that Mr. Gregg? I mean, going back to what Judge Valenti said, the trial court is a trier of fact that gets to credibility. And in this case, and I'm looking at the judge's finding, the judge basically said, he remarked, certain documents conflicted with each other. He also concluded there was a significant lack of evidence, and he would have to speculate to calculate specific figures. Isn't that a trial court's prerogative? And following back to what Judge Valenti said, that regrettably, the trial court really did not find your expert credible on this type of issue.
Correct, but that would be contingent upon this court finding that competent substantial evidence supports the trial court's finding, because that's what's essentially being reviewed.
No, and I appreciate that, but that's substantial competent evidence if it is accepted. We're dealing with a determination as to credibility.
Sure.
So if, let's just say, a witness would say, I saw this accident, the light is green. There is evidence that the light is green. And then the jury rejects it, saying, we don't agree that the light is green. You're asking it to say, well, there is competent substantial evidence that the light is green, that we should basically dissuade or basically set aside the jury's finding. This is what I'm getting at.
I understand. Yeah, I understand Your Honor's point. And it wouldn't be that I would be asking the court to substitute my preferred interpretation of the facts to get to the conclusion I want. What I'm saying is there is no competent substantial evidence to support what the trial court did, where the trial court said there is no retroactive relief, there is no prospective relief, and now we're going to impose a bunch of additional extra contractual terms on you, where you have to exchange this financial information.
I don't want to interrupt, but I do want to let you know you have 30 seconds until you get to the 5-minute mark.
Thank you, Your Honor.
Reserve that until you.
So to return to Your Honor's question, I believe that the trial court did not have any competent substantial evidence to do what it did, which was deny any relief to the former husband, deny any reduction, because we know that the wife is receiving Medicare, we know the amount, we know she's receiving Social Security disability, we know the amount, we know she has reasonable supplemental insurance. But again, as Your Honors have pointed out, this does largely turn upon the interpretation, which is the first issue on appeal. With that, I will reserve the balance of my time.
Okay.
Thank you.
I'm going to give you the full 5. You're a little bit below 5, but let's move on to your opponent. Ms. Grossman, you can start.
Good morning, may it please the court. Mr. Gregg, I represent the former wife, Charlene McKay. I'll start by addressing the first issue raised by the former husband in his initial brief, and that is—
Actually, Ms. Grossman,
yes, sir.
if you could pick up where he just left off, that's an important issue. I think it would kind of flow from my thought process. He left off on the point that if the court's interpretation is correct and the original agreement anticipated that there would be some reduction at some time if you got Medicaid benefits, how does the lower court's ruling ever allow that to happen? Or are you seeing this as an action in process and that there's actually not a final judgment in place to Judge Kazam's initial question today?
Well, I think there's 2 questions actually from that. And one is, even if the trial court had determined that there was no judicial labor to be had, that the court had decided the issue of the current amount of the health insurance component and the alimony amount, if that was done, I believe this would still be a final order. But unfortunately, because the parties' agreement is not as artful as it could be, they both had attorneys, but it could have been worded differently. Unfortunately, we're going to have a final order once the judge determines the current amount. And if and when the components change, the disability amount changes, we are going to have yet another order entered, which determines yet another current amount of income. It's just the way it has to be.
So if I may, Ms. Grossman, I'm trying to find out, and that goes back to the jurisdiction issue before us. Mr. Gregg made a comment, or at least his position is that the court's interpretation that, hey, this is what the former husband needs to do, that by itself is a final determination. It's res judicata in terms of the former husband's obligated to pay, but whatever the amount is, that's kind of ongoing. It's fluid. And what the trial court did in this case allowed the parties to bring in, because did not find anybody credible, and just to kind of nail the amount. So for our consideration, is the trial court's determination res judicata, or is this still a non-final order for purpose of our jurisdiction?
That's a good question. I can accept either position, but I think legally the best position is, because the issue of the current amount of alimony going forward was raised in the former husband's motion, we have to have a starting point. And because that was not determined in this lower court order, that it requires additional judicial labor, and that this is not a final order. What we're anticipating happening in the trial court one day, and it hasn't happened yet, is the judge asked for the parties to exchange information on the current components of the health insurance / alimony provision, and a dollar amount will be set in a court order. And I think that has to be done, especially in this case, because the parties have been litigating for over 5 years on this particular issue.
Why wasn't that presented in the trial in this case? Wasn't there a disability award made during the pendency of this petition? So the husband's asking for credit of the disability against the alimony?
Yes, but we had ongoing disputes with the Medicare cost and the supplemental insurance.
But it's not a black and white issue.
Well, there's basically 3 components, and because they were in the transition period from going from pure alimony to alimony plus disability, and then adding the Medicare cost, which changed, and then the supplemental insurance.
Okay,
cost, which
but
changed.
why did the judge limit the relief to prospective only? The agreement was anything that the wife got from disability and various offsets would be applied from ab initio. So you have a 5-year window where all of a sudden that relief is wiped out. I'm just trying to figure out, did the judge have the ability to do that and then just say, give me all your figures and I'll fix it later? But he denied relief from when this petition was filed. I think that's goes to his argument that this is a final order, at least as to the past determination, that effectively says there's nothing owed. I'm not going to go there. You guys are fighting like dogs. I don't want to hear it. Let's move forward and try to make nice. I mean, it looked like he was frustrated with both sides.
And I can accept that position too, because I think ultimately, when we get down the road, we're going to find ourselves in the same place.
Well, but that's speculation. We don't know. They want a black and white determination of credits, whatever, and let's see what is actually owed and adjust the alimony up or down, or just leave it the same. But give me some facts and figures that really applied here.
Well, I think, Your Honor, respectfully, I think what the trial court did was he basically said, I've sat here for 2 days. I don't believe Todd Berg. His testimony is not credible. He didn't even just find that Mr. Berg was not credible. He devoted 4 paragraphs
Right.
to the lack of credibility issue. And so at the end of the day, he says, listen, we're 9 years out from this final judgment. 5 years after the former husband presents his motion, I still can't tell from the numbers that were given to me whether or not there's been an overpayment of alimony. So you know what? There is no substantial competent evidence which will allow me to determine that particular issue. We're done. If there's no evidence, I'm not going to speculate. We're done. You don't get yet another 3rd day in court to try to
So your
clarify
argument
all
is there's
that.
a failure of proof.
Pardon me?
Your argument is there's a failure of proof.
Absolutely.
The husband was given the burden to prove X, Y, or Z, and the judge said, you didn't prove it. That's why it's prospective.
Absolutely. So he said, listen, you guys exchange your information about what the current costs are and try to come up with a number. And if you can't agree, come back to the court. So that would lead to the argument that this was yet a non-final order on enforcement.
All right.
Let me play the devil's advocate, Ms. Grossman. The court's determination that because the husband failed to prove that what was done in the past, wouldn't that be considered a final order for our purposes?
On that issue, yes. But we still had the issue of, which was raised by the former husband in his motion, is to establish what the current amount is going forward. And I don't think the legal analysis is whether or not on these 2 issues raised on appeal that the trial court made a final determination of those. That's not what we look at to determine whether an order is final. We look at the order to see if there is something in there that requires additional judicial labor. That's my opinion.
But that wouldn't require judicial labor as to the past determination. That
Correct.
you lost, you didn't prove anything. Going forward, yes. So you may have a hybrid type order here.
Yes, and to be honest with you, Your Honor, when I first read the order, I did have a fleeting thought that this might not be final. Unfortunately, as I get older, more and more of my thoughts are fleeting, and I never circled back. I think my focus was on, and Mr. Gregg's as well, was that the litigated issue was whether or not there was an arrearage. And it came down to, the 2 issues, the interpretation of the agreement. And I have to tell you, quite frankly, when I read the former husband's position, his argument that this was just to be a one-time adjustment and nothing moving forward, my initial thought was, well, that would not be fair to the former husband, because we know that Well, realistically, all of these components are going to increase. The income's going to increase. And will not the former husband want then a reduction in his that portion of the alimony for any increase in Social Security? And the same thing for the health insurance, the Medicare and the supplemental insurance component. If that's to his benefit, he will most definitely be back in court seeking an adjustment that would benefit him. But at the end of the day, the judge was extremely frustrated with the lack of credibility of Mr. Berg. And the judge's comment, I think, sums it all up. And he basically said, there is a significant lack of credible, competent evidence this court can rely on. This court would have to speculate to calculate on its own the years of changing numbers in this specific litigation. This court cannot and will not do this. And it's not our job at the appellate level to cull through all of the numbers that were presented, the confusing testimony in the transcripts. I've been involved in this case now. This is my 4th appeal on this very issue. And I have to be honest with you, after one reading of the transcript, I was still scratching my head thinking.
Well, one of the things that we don't have is the former wife didn't bring an appeal, but the judge also found that she didn't carry her case, her burden, all her stuff was not credible either. But that's not before us, but there was a mutual spanking going on here.
Yes.
Okay.
And I'd like to point out, there has been a finding made by a subsequent judge that the parties have been hotly litigating for 9 years. And I'd like to
if it's off the record, no sense poisoning the well with that.
Okay.
That's not, who cares about the subsequent judge? Okay.
But I'd like to point out, because this relates to the issue of attorney's fees, we filed a motion. This was a long-term marriage. The reason why the wife is fighting so hard to maintain this quality of insurance is she has, and it's been found and not disputed, she has extremely serious health issues. So it's not an issue where she can say, okay, I'll settle and I'll take $300 a month less. It's just not possible in this case. And if you look at the litigation, truly, if you look at the docket, which is a part of the record, this is his 4th appeal, and significantly or substantially all of the motions filed in the trial court were by the former husband related to this issue. And it's extremely important to her to try to maintain this quality of insurance. So I disagree respectfully with Mr. Gregg that the trial court did not have the substantial competent evidence to find what he did. I don't think that argument really applies. I think what we can say is that the trial court had the discretion to find that there was no substantial competent evidence, and that's within his purview. We're not to reweigh the credibility of the witnesses or the evidence at this point. And based on that, we would ask the court to affirm the lower court.
All right, thank you very much. You're all done. I'm going to go, Mr. Gregg. I said give you 5, and I will.
Thank you, Your Honor. Just quickly, in responding to the allegation that Mr. Cook has been responsible for all the appeals, it's not a complete representation. Once the last appeal occurred here, and this court found that the order on appeal was a non-final, non-appealable order. At that point, the former husband attempted to obtain discovery from the former wife about her Social Security benefits, about her Cigna health insurance when it was converted from a private policy to a reasonable supplemental insurance policy. And for each of those items, the former wife objected to producing the documents, objected to the non-party subpoenas. So it wasn't like we had a cooperative person here trying to give us the information so we could make.
Before you respond to that's kind of a personal attack, why don't you tell us about what do you want us to do exactly? You want us to find that what the judge did with the past determination was illegal, was wrong, improper, or the prospective interpretation saying, give me more data? What is it you're looking for us to unravel here?
Ultimately, I think the most important thing for the court to do is to make a final determination about what is the interpretation of paragraph 13. because that will at least give the parties a pathway forward, whatever way that pathway may be.
Okay,
From the former husband's
okay, before you go there, didn't you say earlier, no one raised the issue of an ambiguity, therefore there shouldn't have been parole testimony, any kind of testimony as to the interpretation. So how do we get to rewrite this whole thing? It sounds like a kind of a mess. Isn't that something the trial judge would have to normally sort out?
I believe your honors could do it as it's de novo review, and I believe the plain language allows.
But the argument wasn't raised below. You're raising an argument now saying you want us to figure out what this paragraph 13 means, but you said no one argued below there was a need for an interpretation of an ambiguity. That's
Correct.
A little bit inconsistent in my mind.
Okay, well,
I'm just saying,
respectfully,
right? You can disagree, but if you give me a reason.
I respectfully, I don't agree, because I don't think the fact that, well, I'll just leave it at that.
Right,
Well,
fair enough.
let me see if I could maybe, if I understand your argument, Mr. Gregg, you
Yes,
basically,
Your
you're, when Judge Valenti is asking, what do you want us to do? You want us to make a determination whether or not the trial court was correct in ruling as to the past
Correct.
peerage. And secondly, you're taking the position, I know you mentioned about paragraph 13, whether the trial court's interpretation that this is an ongoing, whether
Correct.
that was correct or not, you're taking the position that he was not correct, that it's a one-time thing, but the court held otherwise. So basically what you're asking us, as I hear your argument, not to interpret, but basically to give either the thumbs up, thumbs down to the trial court's conclusion as to whether or not this is a one-time thing or ongoing. I'm just trying to wrap all this up.
No,
Is that
you're
what you're
doing a
arguing?
wonderful job of
Oh.
helping me out.
No,
No, thank you so much.
No,
I knew
I'm
I
just
was
trying
helping
to,
you.
I'm just trying to focus as to what the issues are before us for
Absolutely.
resolution.
And
And given the fact, as Ms. Grossman said, and Judge Valenti and Judge Starr said, this has been an ongoing case, and it's regrettably you see cases like that that's been ongoing for a number of years.
this is one
But
of those
anyway,
cases.
I just wanted to make sure that we don't get into the ambiguity part, but just to at least what's before.
Correct. As far as, yes, Your Honor is absolutely correct in terms of what our position is and the relief we're seeking. Additionally, we're asking the court to take a look and determine whether or not competent substantial evidence actually supported the court's findings. But ultimately, I think issue one, if that's resolved in the former husband's favor, then the case will be remanded to the trial court, and at least we'll have some definitive guidelines and actual law of the case to go forward and figure out how to do what's next. I would also ask that with regard to the court's determination, there was a mention that it's the issue of the retroactive relief is not final. And I just wanted to mention that I cited this in my response to the court's order to show cause, that an order that liquidates a support arrearage or overpayment is a final order. That's Remington v. Remington, 705 Southern 2nd, 920, Penn site 922-23. And that's from the 4th DCA of 1997. So I believe that issue is a final order. And because it is, if this is affirmed, then the former husband has been completely denied any relief, despite the clear, plain language of the agreement stating that he is entitled to that relief back to the date of the first such regular payment, both with regard to the
You just ran out of time.
I'll leave it at that, and I'll thank your honors for your time and consideration this morning.
All right. I want to thank you both.
Thank you.
We're going to move on to the next case,
Thank you.
which is Kurtz v. Kirkendall.